call the Forensic Science Commission Complaint Committee meeting to order. It is now 7:35. So the first case is that of Eloy Red. And that is
You got a tab for him.
yeah. Is that the first case?
Well, there are two self-disclosures, and then the complaints start with
Number 3.
Mr. Red. So we can do the disclosures first or last, however you
We
want to
can
do
do the
it.
disclosures first.
Okay.
The first disclosure is from the Boston Police Department, a crime scene report. Which tab is that? I'm sorry. Lost track
It's-
here.
It's just for the Corpus Christi one.
It's under tab, if you go to tab number
3.
3, right.
Yeah.
And there's one for APD and one for corporate.
So it's on page 3. after
Okay,
that.
so the first complaint is from Bill Gibbons. And his complaint alleges. Hang on. I put my glasses on.
We're doing Austin though.
The complaint was that it was a questioned the workload of one fraternity crime scene technician. He found that there were 11 reports that were issued that they couldn't find information about. They instituted an internal affairs investigation. And if this was a systemic error or it was just a generalized error. And they are finalizing a corrective action report. We didn't get the corrective action report, did we?
Not yet. They're
Okay.
still, I talked to, the lab director yesterday, and he said they expect to have, a car worked up within 2 weeks from now, and they'll forward it to us. I think the main thing that happened was, from what I understand, the supervisor sort of started looking into this crime scene technician's workload and realized that he was going out to the scene and not coming back and doing the reports he needed to do. And then when they audited his workload, they found another 121 where that was also the case.
So just for my edification, he's not doing the work. He's going out there conceivably to the scene, he's doing crime scene work, collecting evidence, and then he's not documenting it? Or he's going there and he's not doing anything?
These appeared to be, from what my reading was, that no evidence was collected on them.
So what's happened is,
Okay.
the original thought that was that no evidence was collected, but APD has gone to interview all the victims, and some of them said they thought he lifted prints.
Which is a bigger issue.
Mhm.
And so, but it's possible that when he got back, even though he might have looked like he was lifting a print, there was nothing to examine. And
Right.
so, but the presumption is that no. I mean, even if to the victim it looked like he had lifted a print, it may be that there was nothing there when he got back. But they think that in all of these cases, there was no evidence, and he just essentially didn't bother to do the report.
And I presume that it doesn't make clear and also whether or not these are all cases that resulted in an actual case being filed as opposed to possible case, some of these are cases where there was no charge that came out of the work.
I think we don't
We don't know.
We don't
Okay.
know that yet. And I also think that that was I believe one of the follow-up questions from Ask Cloud Lab, they asked a bunch of follow-up questions when APD first disclosed this, and so, those are behind, well, they should be there. Where's the Ask Cloud Lab correspondence with APD? I don't see it here. So what happened was when Bill gave the initial disclosure, Ask Cloud Lab came back with a list of questions. And those questions include, they want confirmation if the internal affairs investigation has been completed, confirmation that all customers affected by the nonconformity have been determined and notified, and so I think they mean law enforcement. Summary of any additional corrective action identified by the lab to prevent recurrence of the nonconformity and the status.
Okay.
Confirmation whether the investigation has been completed. So there's a bunch of work that needs to be done in terms of follow-up. And one of those questions might be, what is the disposition of these cases? From what I understand, nothing happened on them because they came back and they didn't find anything, but I don't know that.
Okay.
And part of the problem that the lab director was explaining to me yesterday is that the LIMS is separate from the computer system that is used by the crime scene analysts when they come back to the office. So it's not like they come back and put a case into LIMS. They come back, enter it into that system, and then if there's evidence to be worked, it goes into the LIMS. So from the crime lab's perspective, in terms of its operations, it wouldn't necessarily have caught these cases in the LIMS.
Okay.
But they're setting up systems which will be part of the corrective action to account or to try to close what he referred to as sort of a loophole, which is basically that there's no communication between the two systems, except if you're trusting the crime scene analyst to do his job, which is what they were doing.
It seems like we might benefit by getting the responses to the last part from ASCLD before we went further, as far as whether an investigation or a panel was needed, or there's nothing further that needs to be done.
And do you want me to ask the lab director for whether they've assessed if cases were filed or not?
I'm interested in the breakdown as to of those cases where they determined that there was no documentation of his work. What, if any of those resulted in or connected to cases where files were charged or not? In other words, if there's, because that obviously, that from a impact standpoint, if it resulted in no charges, it hasn't impacted anybody, hasn't impacted anybody who's been arrested. So I just.
No, I don't think it has. It has. I think the bigger concern is the perception of the community that calls and expects that if a victim, I mean, basically it's a problem with the community relations primarily, because the victims are calling in. These are not violent crimes. They're theft of auto or break-ins when there was no inhabitants, home break-ins when nobody was there. But still, I mean, the expectation is that if you call APD, they're gonna do everything they're supposed to do.
Okay, I get it.
So is the recommendation to reserve any decision until we get some responses to the complaint form?
Yes.
Yes.
Well, any further discussion? All in favor of this recommendation, please say aye.
Aye.
Okay, the next is Corpus Christi Police Department, was the evidence control. Apparently it was discovered one bullet fragment was missing from a case pending examination by the laboratory. So on July 23rd, 2015, the Corpus Christi Police Department realized, and the crime scene investigator, Donna Diorca, realized she was missing a bullet fragment from the aggravated assault case. She completed an unsuccessful search for the evidence. She notified a supervisor several days later on July 27th. where the laboratory explained her services. She had 5 pieces of evidence labeled 1 through 5, 2 casings, 2 cartridges, and 1 fragment. She labeled, photographed, and collected the evidence, and when it was received, upon returning to the laboratory the next day, she realized item 5, the bullet fragment, was missing. On August the 6th, the crime laboratory quality manager Kathleen Quesada reported the incident to the forensic service manager John Hornsby. Hornsby met with both Quesada and Dorcas to discuss the incident. Hornsby reported the incident to both the Forensic Science Commission laboratory accredited by the Asplet Lab. The laboratory performed a root cause analysis to determine the fault sequence and prevent any recurrence of missing evidence. That the laboratory's opinion is the crime scene investigator who handled the evidence did not handle it in a manner consistent with best practices for evidence collection, documentation, and preservation. The primary causal factor was determined to be general employee negligence, though no particular laboratory policy was violated. As part of the laboratory's corrective action, laboratory counsel and trained the crime scene investigator involved in the incident. So, the staff recommends that we reserve decision of the disclosure until the laboratory provides a response to questions posted by Asplet Lab provided in your materials.
So I'd like to amend that recommendation
Sure.
because this document that Lee passed out is back and forth that we got yesterday between the laboratory and Asplet Lab. So the laboratory responded immediately to all of Asplet Lab's questions, and Asplet Lab has closed it out. And the only reason, I think, to continue this on to another meeting is to give commissioners sufficient time to review. I have reviewed it. I think they've done everything humanly possible. I would like to point out that in terms of the timeline, when the lab director, John Hornsby, he found out about this at 9 a.m. on August 6th. He called the commission at 2 p.m. on August 6th.
Quick response.
So, you know, I mean, they've been very transparent from the beginning. And it's basically a case of, she made a mistake, it was there and then it wasn't, the bullet fragment. And it does not have an impact on the case results because of the other evidence they were able to collect. In terms of the criminal case outcome. She's gone through remedial training, they've done a full car. I don't know what else they can do. I mean,
No, I agree. I mean, just, there's some, so can we just, can that just be we have the option of making that our finding or recommending to the commission that we're satisfied with the corrective action, there's no further work that needs to be done?
yeah.
That's what I'd recommend. There's no point carrying it forward.
I agree with that.
Okay, so we have a second, a third. All in
Okay.
favor of the
Favor.
recommendation? Okay.
And I have to say, with the lab director, I mean, he's called me multiple times and asked for guidance, and, I mean, they've been on it. So, that's good.
Okay, so we'll go to the new cases. New case is 1110-15, or sorry, .15.08. Eloy Red, it's a sexual assault examination and testimony. On November 4th, 2003, the complainant Eloy Red was convicted of sexual assault of a child and sentenced to 4 years in prison. Complainant alleges his conviction was based on a child's version and statements, police interviews, and CPS caseperson testimony at trial. The complainant complained that her bottom hurt and made additional statements to school nurse and principals. School nurses reported concern of potential sexual abuse of the victim. The victim was interviewed several times by CPS caseworkers, both in Harris and Fort Bend counties. Because there was some confusion about where the child resided at the time, she lived with her aunt and visited her mother frequently. The mother was in a relationship with complainant Eloy Red. complainant sexually, where complainant sexually assaulted her and described the incidents during videotaped police interviews. The victim received an examination by a sane nurse and real evidence of penetration corroborating her complaints. All right, so the preliminary recommendation is that potentially that the complaint be dismissed, even if the commission agrees that a sexual assault nurse examination is forensic analyst as set forth in the commission's statutes. The commission doesn't have the resource to investigate the same examinations at this time.
So the bottom line is that, yes, there are issues with sexual assault nurse examinations. We've seen them in many cases. The San Antonio 4 is an example. What's that other one? The Kellers is an example. But there is a board of nursing that governs nurse behavior, number one. Number two, you'd have to do a lot more vetting. And I don't know how we would even start trying to figure out whether sexual assault nurse examinations, I mean, I just don't see it as something that is possible to do or even should be a priority because we have so many other issues on our plate. So even if you agree that sexual assault nurse examinations are forensic analysis, which I believe they are, I just don't think we have in this particular case. I don't know how we would even investigate the appropriateness of the conclusions, because his main complaint is that the SANE is improperly influencing the child
Right.
in the interviews. So that's something that I don't think is tangible enough. If we were to look at the results of the examination itself, I mean, I think we should send it on to the clinics who have experience with these types of cases and see if any of them want to vet it and if they think there's anything there.
Well, we don't cover testimony either.
Well,
Part
we
of
sort
this-
of do.
Well,
But that's all
Yeah.
it is.
But this isn't, I mean, again, it's not exactly testimony, but it's more that he's saying that the procedure itself created false evidence.
That got entered in the form of
That got into
testimony.
the form of testimony, right. No, I agree. I mean, it's just, I think there are organizations that are better suited to deal with this, and I think if the commission tried to take it on, we'd actually be having to create a committee that is staffed by the very people that we need. We need lots of expert input on it, so.
We couldn't do it, I don't think, even if we wanted to.
So the suggestion is that we dismiss this complaint.
And send it on to the Board of
Board of
Nursing,
Nursing.
which we've done in the past,
Okay.
and also to the various clinics.
I'll move that we dismiss the complaint and forward it to the information of the Board of Nursing and to the innocence organizations for follow-up.
a second.
Okay, all in favor, say aye. All right. Okay. The next case involves a 2001 complaint against James Edward Wilcox, who was convicted of aggravated sexual assault of a child. Jury assessed punishment enhanced by 2 prior felony convictions to 45 years in prison. The alleged victim was a 15-year-old girl who testified during the early morning hours of March 7, 2001. She left the house in search of crack cocaine. She encountered an acquaintance who led her to a house where they had sex in exchange for crack cocaine. She then wanted more crack cocaine, but the acquaintance would not give it to her. Instead, he directed her to the complainant, James Wilcox, who was the owner of the house, and the acquaintance left the house, and the alleged victim sat on the couch with the complainant. The alleged victim became furious when she discovered the complainant did not have any real crack cocaine, but had some other substance. When she tried to leave, the testifier would not let her. She testified complainant put his hands on her throat and informed her that she was not going anywhere. The alleged complainant sexually assaulted her while she lay on the bed crying. The complainant alleges that the DNA to convict her was not properly tested. He also challenges the initial blood draw and chain of custody of the blood used to perform DNA testing. It's not clear from the complainant specifically when the complainant alleges was wrong with the DNA testing and chain of custody in this case. The complainant does, however, provide testimony excerpts of DNA analyst testimony. He also provides a letter from an attorney dated August 15, 2006, in which the attorney states he was informed that, in fact, there is a new DNA evidence that exonerates the complainant that was not available at trial. The attorney also states that the alleged victim recanted her testimony. The attorney requests the complainant pay him $2,500 to get reviewing transcripts. There's no other correspondence with the attorney in the materials.
I asked Nick to look into this, and at first, I thought they were just sort of vague, random allegations, but then when I saw the letter from the lawyer, that caused me some pause, because he's asking for a $15,000 retainer and $2,500 to look at the transcript, and he says there's DNA evidence that exonerates you, and
Which was not available at trial.
and the victim recanted her statement. So one of two
what
things
is
is,
it?
I have no idea what's going on here. If this is an attempt to get money from the guy, or if it's genuine, and if it were, don't you think as an attorney you'd have an obligation to do something?
Well, at the very least, you'd bring it to the attention. If you have evidence that exonerates your client and you don't let the state know about it, then,
What do you-
I'm troubled by this. I almost feel like the state bar would be interested in looking
Yeah,
at this letter.
right?
Because it's kind of like, I've got something that can get you out of prison,
Just
but
pay
and
me
for $15,000,
Gs.
I will give it to you. Did you find anything?
Well, he's filed, I think, 5 writs. This letter was in 2006. He's had, I think, 3 or 4 of those writs filed post-2006. From my experience, just because someone is saying, well, someone's recanted and we have exonerating DNA, that doesn't mean anything until you actually see it. So we haven't seen a DNA report at all.
So none of the writs you're talking about, there was no evidence presented?
I
supporting-
haven't seen what was filed on them. I think most of them were denied on subsequent writ grounds. That's what it looked like.
Okay.
But a recanting witness, she may have recanted pre-trial. So the fact that she recanted, we don't know that it's even a viable legal, option. In 2006, it's probably not viable at this point at all. It's just because a lawyer says he has exonerating DNA evidence, that may just mean they did a DNA test and there was nothing there at all.
Inconclusive or something.
Right.
So I think there's a lack of information. There's a lot more he probably could have shared other than a 2006 letter, because there's been a whole lot more that's gone on with the case since 2006.
Okay.
So, for me, forgive me for being skeptical, but from where I've sat and read letters like this before, there's a whole lot more information than one single letter from an attorney with some possibly helpful information in it. I just think we're missing a lot of information.
So on that, but I do agree with you, Richard. This is concerning to me, this letter.
But it's not, again, if there really was DNA evidence that exonerated him, in light of everything we're dealing with DNA, if there really is some scientific evidence out there, then I think that the commission would have an interest in that. But I think what I'm hearing is that there's been a selective sending of stuff
Right.
that, there's been.
We don't have a whole story.
Exactly, so.
Do you know who represented him on the writs? Anybody?
No, and I think he has a pending file at one of the Innocence clinics, I think. So we could always follow up with them to see what they have. Just because of the bold statement in there, I would be interested to know if we could follow up with them just to see,
if they can speak to that, because I'm concerned about the letter. I'm concerned about the letter, I mean, wiggle room aside, I mean, if it almost, I don't know.
Extortion.
Yeah, that, what you said could be extortion.
No, but either, one of two things is happening. Either
Either the lawyer doesn't understand science and law and is making statements that are unsupported by facts, or the lawyer is making stuff up to get paid money, or the lawyer is making statements he thought were true that further investigation showed were not true, and that's why all these writs have been denied. It's kind of going to be one of those.
They talk in testimony about a mixture that says consistent with the complainant and some unknown individual, but it was like 1 in 80 million for Caucasians and drops down to 1 in 42 million for Hispanics, but I don't really know if that's a mixture, so that goes back to, what does that really say? I don't really understand what they've got here.
It doesn't seem to be a super complex mixture, so it's a two-person mixture, so I'm a little less.
But then it still goes back to whether, if she recanted her testimony, whether that was sexual assault or not. That's, of course, at her
Right,
age. I guess her age is part of
yeah.
the issue.
I think, I mean, again, I think, and I would move that it be dismissed for the reasons stated, that there's no professional misconduct or negligence alleged, but I would also like staff to follow up with the innocence groups that are looking at this. I'd just like to know the rest of the story, in particular as to the allegation that there's DNA that exonerates.
Yeah,
So-
and basically, what is this letter all about?
Yeah.
I mean,
Well,
It could be forwarded on to the
It
bar. I
kind
guess.
of, it kind of speaks to some of the concerns on another DNA issue we're looking at about as to what the response of lawyers is going to be when people say, I got a letter that says there's a mixed DNA issue, and whether the response is going to be, I think you're right, and for $10,000, we
Yeah.
can.
We can look at it. Yeah. So do we have any recommendations?
So that, I would move we dismiss it, we dismiss the complaint for, because it doesn't allege professional misconduct or negligence. For that, we ask staff to follow up with the innocence groups and get an answer or more information about the DNA and the recantation issue.
Second.
All right, all in favor of doing that? Aye. Anyone opposed? Okay. So the next case is another 2001 complainant. James Edward Wilcox was convicted of aggravated sexual assault of a child. Oh,
We just
We
did
just
that.
did
just
one.
did that, yeah.
Now, we're number 3.
Davis.
Actually,
Sitting
having
look-
a complaint that has some words I understand the meaning of.
Stevie Davis is what we're on.
Yes, okay, you're right. Complainant Steve was convicted and sentenced to 35 years in prison for intoxication manslaughter for incident that occurred in Kaufman County on May 4th, 2002. At the time of the accident, the complainant was administered extensive intravenous drugs by rescuers in Carefly helicopter. Complainant claims that the IV drugs were administered before the blood used to test his blood alcohol content, and the IV drugs contained benzyl alcohol. Complainant claims he was not drinking any alcohol at all before the accident, but the blood test shows a percentage of alcohol only because of the IV that contained benzyl alcohol. Complainant claims he was falsely convicted based on the forensic blood analysis report and testimony given by DPS Garland analyst Chris Youngkin at trial. The complainant claims Youngkin failed to consider the IV medications in providing the blood alcohol analysis. On September 17, 2015, DPS Deputy Assistant Brady Mills provided the commission with the following response to the complaint. The alcohol that is reported at the DPS level would reflect ethanol or ethyl alcohol. Benzyl alcohol has a higher molecular weight than that of ethanol and does not interfere with the headspace analysis that is employed with the DPS laboratory system. We ran a volatile mixture sample in several different alcohols and other volatile substances. The gas chromatograph is able to separate different alcohols and other volatile substances. Okay, so in light of the DPS explanation of GCMS instrument separation of different alcohols, staff recommends that the complaint be dismissed for failure to state an allegation of professional negligence or misconduct relative to a forensic analysis.
Yeah, I see where the, where he saw what he would consider an opening, because the report said alcohol,
Right.
not ethanol, and if it said ethanol, it would have been, I think, a little clearer, but they don't come off at the same point, and so it's not all alcohol. This is ethanol that they're detecting, so I agree that it's dismissible. My recommendation is we dismiss it.
I agree. I'll second the motion.
Okay. All in favor of dismissing the complaint, say aye. Aye. Any further discussion? No. Okay. The next is Rodney Haslip, a DPS Houston alcohol, blood alcohol case. On February 14, 2011, a Montgomery County jury sentenced and complainant Rodney Haslip to 40 years in prison for his 5th DWI offense. On April 19, 2010, the Montgomery County Sheriff issued an attempt to locate after multiple citizens reported seeing complainant driving erratically. One witness and his 4-year-old daughter witnessed testified that they were walking home from work when the complainant sped by. The witness had to pull his daughter out to avoid being struck. Moments later, the complainant crashed into a fire hydrant on a witness's property. The complainant fled, but he was later picked up walking near the accident scene and arrested for DWI. 4 hours after the accident, the complainant's blood alcohol was tested, and the count was recorded at 0.26 times more than the legal limit, more than 3 times the legal limit. The complainant criticized DPS Houston analyst's opinion regarding retrograde extrapolation of blood alcohol samples. Complainant claims that more than 4.5 hours after his arrest, there were no factors available to conduct retrograde explanation, and therefore the results were false. The complainant also disputes the testimony of the analyst when she notes the defendant could not have become intoxicated after the alleged accident, but prior to the arrest. Complainant claims he was out of custody for an hour, and there is no evidence of what he was doing during that period. Complainant also alleges the analyst did not follow proper procedures that require 2 blood alcohol tests. The complainant alleges these same issues on appeal, and the appellate court found the error of the retrograde exploration was harmless because there was significant evidence to prove the complainant was intoxicated other than the testimony related to retrograde extrapolation. On September 21st, 2015, the DPS Deputy Assistant stated that the analysis performed the forensic analysis in compliance with DPS protocols, but not provide any further detail. Deputy Assistant Director Mills will be available for Commission's quarterly meeting. Commission staff refers to toxic reports to the Commission to review the reports and related testimony provided and assess whether the allegations regarding improperly supported retrograde extrapolation related to testimony merit any further investigation.
Without claiming to be a scientist with an expertise in toxicology, I have familiarity with it, and I would like to hear Brady knows answers. I've talked to a local toxicologist, and it's kind of, I think there's a lot of things going on here. I doubt the allegation about the 2 testing not being done is correct, because every gas chromatograph testing per protocol is always going to have, it's always going to go through the instrument twice. But as far as the testimony in court, the answers I got from my expert, who I trust and understands this stuff, is to a certain degree what he thinks is going on is that the answers are correct, but to the wrong questions. That there's a combination of things going on here. There's some badly worded questions that perhaps the witness should have declined to answer, or should have gotten clarification on, or there was perhaps, as is more typically the case, a pretrial meeting where there was like, I'm going to ask you this, and what would your answer be? And they were answering the question they should have been asked. But I'd like to hear Brady's comments on this, because I think this is an area, certainly an area of concern, and not the least of the concern is that judges, even courts of appeals that are giving opinions, are referencing factors that have nothing to do with retrograde extrapolation, like, in my understanding, body weight. There are factors that keep coming up. I think it's important that the correct factors be dealt with, but I don't think the appellate courts are always as helpful in explaining what information we need. So,
Because it says here, we conclude, so this is the appellate court, we conclude that the state did not show that Stafford, so the analyst, had sufficient facts regarding Haslip's characteristics and behaviors to make a reasonably accurate estimate of Haslip's blood alcohol level at the time he was driving.
Let me say, did I misread this? Or 4.5 hours after he was arrested, he's got a .26 alcohol?
no, that's correct.
That is
That's it.
correct.
So,
there are
does it
things you
really
can-
matter what it was
Well-
4.5 hours earlier in that it's over the limit?
Well, I mean, I think the point is, putting aside the comment that no one knows, according to the person who does know, what he was doing in that hour in between the stop and the wreck, I think again, I think from a scientific standpoint, there's no question a lot of alcohol had to be consumed if 4 hours later we're at this level.
Right.
I think that the complaint and if any part of it has any validity, it goes to what my expert said is really we're kind of left with, we can say he would have been higher, lower, or the same back then.
Yeah.
And it's going beyond that. It's what.
Give a specific number.
Exactly. If you don't know sufficient details, like when, I mean, the most important one is when his last drink was. Again, arguably, unless there's something wrong with the police custody procedures, his last drink happened before he was handcuffed. I don't think he got any alcohol after he was arrested. So I think that's the way I read it.
I
Yeah.
don't think, that he was between the time of the accident and when they cuffed him, an
Yeah.
hour passed. And I
Right.
think what he's trying to say is,
He drank all that.
But that's not a scientific issue. I mean, that has nothing to do with that's not a hypothetical you would ever ask a witness, because there's no way to answer that. Assuming the defendant drank all of his alcohol for some stupid reason in the hour after he killed somebody, I mean, what would his alcohol level be? I think I don't give that any weight. I'm more concerned about what opinions the witness can give as to retrograde extrapolation and what variables are really needed. And depending on what we hear from Brady, I think this is an issue where I think it might be helpful for the commission to give some guidance to the courts and to the participants as to, here's the limits of retrograde extrapolation, and here are the factors that involve. Because as Lynn pointed out, this was a very blanket statement, insufficient details, but I've seen opinions where the courts are saying what they lacked are things that my understanding is you don't need, like, and correct me if I'm wrong, but his body weight doesn't have anything to do with whether we have retrograde extrapolation. It goes to, if you're trying to determine how many drinks he had, and that's another part of his complaint. And comment in here, which is a little troubling, there's an estimate as to how many drinks it would take for him to get to that level. You can do that, but I don't see anything where in the transcript where it says what his weight is. And if you're gonna list that it takes, I don't remember what it was, 17 or 18 drinks. That's a pretty big guy, I mean, over that period of time. So there's just stuff here that I think is.
Well, then, maybe what we can do is we can move this to the full commission
Yes.
and then let him respond to it, and then we can decide if there's more we want to do or anything else.
I think that's it, because I think since we have jurisdiction over this issue, I think there can be it might be a situation where it's worth giving some guidance.
on
And
what
Brady
is,
will be here, correct?
what is retrograde extrapolation, what factors should and should not be taken into account, how
Right.
testimony should be presented.
Of all the sciences we've talked about since I've been on this commission, I'm fairly confident this science comes up in court more than any other science.
Yeah,
and
I think you're right about that.
And I think, so,
So I make the recommendation that we move this to the full commission for the commission's evaluation as well as hearing Mr. Mills.
I'll second.
All in favor, say aye. Aye. Anyone opposed? Any further discussion? Okay, I think the last case is a complaint against, complainant Jeff Sellis submitted a complaint addressing concerns about the commission's DNA mixer interpretation notice posted on the commission's website. Specifically, the complainant expressed concern about the letter is inaccurate and incomplete because the commission did not consult members of the state or forensic and laboratory committee prior to issuing the directive. the letter is vague. He claims the letter is vague and premature and led the commission, and that the commission does not understand the scope of the problem. I would certainly disagree with that. I think the commission certainly understands the scope of the problem. Really no recommendation with respect to this complaint, since it doesn't allege any misconduct or anything significant. So do we have any further discussion?
No, I think this is, just to get on the record, I think this is a ridiculous complaint, considering the amount of effort that's been put into it. And not liking the results of this whole issue doesn't mean that there's a reason to file a complaint, but I move that's dismissed.
I'll second that.
Yeah. All in favor of dismissing this complaint? Unanimous?
Okay.
I got nothing on that one.
Yeah. You have to recuse yourself, she was involved in drafting that. Okay, you done?
Yeah.
I think we're done.
Oh, wait a minute, are we, no, the other report we're talking about for the whole commission.
Oh, that's, yeah, that's just to try and finish this thing up.
Okay. I mean, is there any reason we need to discuss that before it goes for the whole commission? Are we
I
all?
don't think we can.
No,
Yeah.
not from this meeting.
Okay. All right.